All right. So we're discussing the developments in the proceeding that's presided over by Justice Downs. And from the last discussion we had, and this is on Friday, the 20th of June, and the shorter conversations we had after that, we've understood that Her Honor is obviously going about the conduct of the proceeding as if she had an agenda, and
Yes.
the recent communication that we received from the court, further substantiates that inference that we had drawn. So essentially, on the 20th of June, after the orders were made, where Her Honor simply rubber stamped whatever the LSP had wanted and completely ignored everything we had asked for, and that there was obviously a vast chasm in between what they were seeking in terms of directions and what we were seeking. What they were seeking is basically a guarantee that nothing that we were seeking could be properly heard. So basically no discovery of documents. We had already tried to avoid a lengthy discovery process and just asked for one single subpoena. And, Her Honor didn't issue that, didn't give any reasons, didn't even address the fact that we had asked for the subpoena to be issued. And this is something that was particularly on my mind since we discussed. So these are the reasons that she gave.
Yep.
And this is basically 646. So Current Legal Services Board versus Goodsall number 2, 2025 FCA 646.
Yep,
And
aware of those.
yeah, and she refers to the interlocutory application, and she never actually addresses the particular orders that were being sought through the interlocutory application. Why would she do that? Like, she's talking about the interlocutory application in the abstract, as if the content of the interlocutory application itself is irrelevant. I mean, surely it is relevant to the matters that she's raising about notice and, all the other nonsense. Because, for instance, one of the orders that was being sought through the interlocutory application was that we should be allowed to issue a subpoena regarding the correspondence between Justice Gordon and the Legal Services Board, where they discussed issues about the proceeding ex parte through the LSP effectively abusing its statutory authority and pretending that it was discussing our cases with the judge who would preside over them as part of their disciplinary jurisdiction, and it was part of the investigation of the allegations that they were making, which they never bothered to raise in court. And Justice Gorton then presided over a judicial review proceeding and related proceedings that we had started, seeking declarations about the malicious and corrupt conduct of the Legal Services Board in relation to the investigations. So he's presiding over proceedings where we're challenging the legitimacy of those investigations and where we're seeking all the documents in relation to the investigation, including the correspondence that they've had with the courts ex parte about our proceedings ongoing at the time. And he basically refused to issue any of those things. We have a right, not just because of the necessity of the disclosure of those documents pursuant to our right to a fair and public trial, but also under the uniform law, any complaints or any information that they receive as part of the investigation from other parties, those documents need to be disclosed to the parties that they're investigating, and especially in your case, because you're a lawyer. None of those documents were provided by the LSB to us or Victorian Legal Services Board to us, and those were documents that we were also seeking through the proceedings, which Justice Gordon basically thought there was no need to disclose. In fact, he specifically said that even if he had been privately giving them instructions or determinations or other views about the impropriety of our actions in relation to the issues being investigated, he could still preside over the matters without a reasonable apprehension of bias arising. And we asked him repeatedly to disclose the communication. He would then ask us if we have any evidence or if any of the documents we've discovered about their correspondence with the courts include, a reference to him or any other matter that raises implication of misconduct by him. And he never addressed the issue directly. Always tried to obfuscate and evade this. And then ultimately, when we FOI'd or filed an FOI application with the Legal Services Board for the ex parte correspondence between the judge and them in relation to the issues of the proceeding, when they basically said that they will raise an objection to the production of those documents. I mean, we have made a very specific, narrow request because either they would give us the documents or they would object. Either way, we would know that the documents existed and they had basically engaged in improper communication. And the only proper response would have been, there's nothing of that sort. And, if there was, we would give it to you. But they obviously clarified that they would take an objection. And then we contacted His Honor again with that information. And at that point, His Honor, for the first time, addressed it directly and said he's not going to talk about it. Also refused to give any reasons about it. And all this while, he was just breathless in terms of getting the matters on very quickly. Wouldn't give us any discovery, wouldn't let us issue subpoenas, wouldn't let us file evidence because it would delay the progression of the matters. And then now it's been over 6 months. He's not scheduled another hearing.
I know.
Since his misconduct has been discovered, he's basically hiding. Anyway, so this is not. I mean, forget about the fact that it's just obviously you don't need to know about the law to understand that this is rotten in terms of the judge who is supposed to hear matters only in the public has privately communicated with one of the parties and is refusing to provide information about what the communication was, and the party is also refusing to provide the information, the party being the model litigant. He has also directly taken steps in the proceeding that would have naturally resulted in the disclosure of that sort of communication. So when we subpoenaed their correspondence with the courts, rejected the subpoenas. He preemptively listed a summary dismissal application, basically forced them to have one listed, and then dismiss a number of relief measures that we were seeking, because they would have ultimately resulted in the disclosure of that information. Now, this is relevant to all of this because we have filed extensive evidence of this and addressed this in submissions, that what we're seeking is basically that particular communication between the Legal Services Board and Justice Gorton. Because if that has happened, then he was disqualified when he made the orders that they're trying to enforce improperly.
Absolutely.
And there can be no basis for having any concerns about it, because the narrow scope of the documents and the specificity with which they've been described. I mean, we would be entitled to those documents through discovery.
Absolutely.
And Her Honor does not address that in the reasons for why the interlocutory application could not be listed. I mean, the rules of the court say that you don't need to give notice to the other side when you're seeking a subpoena. The first way it says you can seek a subpoena is by asking orally during a hearing, any hearing. It doesn't even need to be before a judge. It can be before a judicial registrar even, because it's an administrative order, effectively, the order to issue a subpoena. And essentially, this was a constructive failure to exercise the jurisdiction, which is a jurisdictional error. And she does not address that in her reasons. That's one thing. The second thing is that all the narrative that she's created, she's basically tried to go over the top in terms of presenting us as the party at fault and presenting them as the either the innocent party or the party that has done nothing wrong and is basically worthy of the court's protection, without identifying any of the things that they've basically done wrong or the things that we had raised concerns about. So another thing that's very conspicuous here is that she doesn't point out that she refused to even hear my complaint about how the Legal Services Board counsel was misleading her on the day in relation to the subpoena. So they didn't oppose the subpoena on any substantive basis. They basically said,
right,
we had already issued a subpoena and it had been decided against us by the judicial registrar. And this was supposed to be a de novo hearing anyway. So there was no point in lying about it anyway. But that's what she said. I then wanted to raise the matter of the transcript of the hearing. And I said that it's, firstly, you had put on affidavit what had happened. The affidavit had been lodged. And to the contrary, Judicial Registrar Ellis had invited us to send a copy of the subpoena that we wanted issued to her chambers. Our position was that we didn't think she would approach the matter with an open mind because of initial views that she had expressed and the context in which they were expressed during the hearing. And obviously, Her Honor's position was different, which is why she hadn't agreed to recuse herself when we had first raised it during the hearing. She also quite improperly refused to refer the matter to a judge when we first asked it on the 3rd of April. None of that, by the way, is mentioned here. Now, when I tried to make a complaint about the barrister breaching the barrister conduct rules in terms of misleading the court quite blatantly about a factual matter that could have been easily checked before the hearing, and it cannot be an innocent mistake because that was the main basis upon which they were opposing the subpoena, that it had been rejected, decided and rejected, and we were relitigating the matter, a concept which would not apply anyway because this was a de novo hearing. So she understood that if I made the application, the law is clear, the courts have an obligation to basically determine whether or not there has been misconduct once an application has been raised with them. There was no way she could, corruptly find her way out of judging the matter. So she basically forbade me from finishing the submission I was making about the complaint. And she says, no, address the matter, don't make personal accusations. I mean, the law is supposed to be beneficiary for the parties that are before the court. It's supposed to protect their interests from lawyers basically misleading the court or perverting the course of justice. That's the whole point of it. And the authorities are also clear that generally when this happens, it will go undetected. So once it is detected and once there's tangible proof, the court definitely cannot look the other way. So she basically stops me from making the application, and I check her. I tell her that it's not her place to basically stop me from making an application. Her job is to rule on the applications that I make. She says, no, you don't have a right to make the application. This is not a royal commission. I mean, I never understand that, basically, because royal commissions are mechanisms through which the commissioner investigates. We're not asking for the court to investigate. We are ourselves collecting evidence and bringing it to the court for determination. And I mean, the logic is, from what I understand, that if the government body does one thing wrong, sure, you can raise it with the government. But if they do 11 things wrong, then you're the problem, not them. And I mean, there's this.
We have to keep pointing out where they go wrong. Simple.
Yeah, it's what their job is. It's the one job that they have, to basically rule against the government. Everything else, the executive. Everything else the executive can take care of anyway. This is a book. It's called The Quality of Government. Very well written. And basically what the authors argue here is that the best way of looking at corruption is to look at the lack of accountability of executive bodies and the systemic inequality that is perpetrated through socioeconomic institutions. And the best way of eliminating corruption is to essentially ensure that everybody is able to hold the government to account. Because what you're then doing is, firstly, the same people are not policing themselves, which is what happens if you don't allow the public to have access to accountability measures or the enforcement of accountability measures. Secondly, obviously it relieves the burden, because if there's a very small number of people that are involved in the investigation of things, then the chances of things getting caught and investigated timely is negligible. Thirdly, the people who are being wronged have an interest in getting those matters investigated and getting those investigated thoroughly. They're also generally best placed to raise issues regarding the impact of the corrupt conduct and the circumstantial evidence that can be used to demonstrate the intention behind the corrupt conduct. Also, it leads to greater public awareness of the issues, because the public is itself prosecuting the matter. It's less likely to be, concealed within a bureaucratic process. So there's more openness and transparency. And finally, it leads to a deterrence, because people know that they're held to account, and it also builds public confidence in the administration of justice, because people know that they have access to recourse measures, and they can see other people enforcing them. So what Downs is doing is not just bad for us, but it is against the public interest. And so, in fact, I specifically asked her, when I asked her for reasons, I said, here, I request Downs J to provide reasons for her honest decisions delivered via the attached email. So these are the orders for which she provided reasons later, pursuant to that request. Whilst we consider it inappropriate for Downs J, and this is the most important part, well, one of the most important parts. Whilst we consider it inappropriate for downstate to make any decisions in the matters before hearing us regarding her honor's disqualification from the proceeding, we note the oppressive effect of the orders. This is actually a subsequent order. Sorry, this is the 20th of June. This will become relevant soon enough, but let's go to the 17th of June. This is a request for reasons as well. So I served the constitutional notice, which also she failed to acknowledge in her reasons, that a constitutional notice had been lodged and served. Now here, unfortunately, the respondents find the time afforded by the court for the filing of submissions to be inadequate in light of our pre-existing obligations in other court proceedings, including related proceedings over which she's presiding, where the LSB is basically preventing us from disclosing evidence of corrupt conduct by some of their top officials, including the fact that a person who's responsible for judging the character of other lawyers was previously working as an unregistered sex worker. And there are allegations that other top officials at the Legal Services Board were blackmailing her with that information, and then making her take disciplinary actions against some of the people that she was soliciting as clients as an unregistered sex worker. And those people have been threatened and intimidated by the Legal Services Board. And when they couldn't go to any other agency, a government agency, they then came to us and gave us all the evidence, which we were going to use in court to seek declarations that those people did not have the character requirements necessary to be a lawyer, let alone be a person who regulates other lawyers. And the LSB preemptively started another proceeding, the 642 proceeding, to stop us from adducing that evidence in this proceeding. I don't know what the basis was, how they could a different proceeding to stop us from relying on evidence in this proceeding. I know what the practical reason is. It's because they're getting this hack from Lawyers Weekly to write basically self-serving articles about what's happening in the hearings. Complete fucking distortion, which I'll address separately. But they don't want their friendly reporters to have to comment about the evidence of serious corruption that we're exposing. So they're trying to deal with it separately and not let it get discussed in the same proceeding, which would be the proper way of going about it. So, and again, there is no basis for preventing us from adducing evidence, because either it's relevant or it's irrelevant. If it's irrelevant, then we can't adduce it anyway. If it's relevant, then there's either a public interest or other bases to have it excluded. There is none. So it's basically them using their control over the improper control over the various people that they can influence within the judiciary and the registry to gain tactical advantage. But people have been genetically programmed to be able to understand right from wrong. It's how the species has survived, and how corruption of this sort can only last for so long. Anyway,
we've seen this pattern all the way through this matter in regards to accountability, etc. I mean, go back to when we had the we made a complaint against Rapke, and what were we told? We can't make a complaint
because he has statutory immunity.
Correct. I mean, how ludicrous is that? Absolutely.
I think one of the things that's really wrong about this is that they don't tell people from the start that if they just take up a job with the government, then they can commit whatever crime. I mean, the only fair thing is to tell children, at school, that this is how you get away with committing crimes. And then everybody has a fair shot at complete lack of accountability. I mean, it's not fair to the honest criminals who are conducting their crimes more openly, that they get prosecuted, and then the people who are prosecuting them get away with worse scandals.
I mean, it wouldn't come as a surprise to virtually every person that the statutory immunity exists.
It doesn't exist the way that they are contesting. That basically you can hire henchmen as LSB delegates to take opponents out. But I mean, it's the other thing that bothers me about people like Downs and Gorton. I mean, Downs I think is the daughter of a judge, and Gorton obviously the son of a former prime minister. And I'm not casting any aspersions on the parents of either of them, but what I'm saying is that if you are born in the right family and you're loose and dishonest, you get judicial immunity. But for regular people, they get fired, and if they find themselves in the wrong circumstance when they're making stupid mistakes and being dishonest about it, then they even get jailed and prosecuted by all sorts of things. So for all sorts of things. So again, there is no reason for her to be both careless and fraudulent at the same time. I mean, at least she should respect the institution enough to be absolutely meticulous when she's committing fraud, at the very least. I mean, you can't change her character at this stage, but the least she can do is be careful and not get caught so fucking easily. Anyway, so she says that, so I say this to her, that we would realistically need at least until the 7th of July to file submissions. And in expressing this, we are not saying, we're not waiving our right to seek a recusal, or representing that she should make orders adjusting the timetable. That's what I say. That her orders are unrealistic. We can't satisfy what she has asked because she ran away from the hearing because she didn't want to address my questions about the reason why she wasn't issuing the subpoena. And I mean, it was so fucking odd. She asked her associate to close the hearing or adjourn the hearing. And I was still talking, so the associate is in an awkward position. She doesn't. And then she has to say it again, Anyway, she runs away. Because of that, she doesn't get an opportunity to ask parties about whether or not the timetable that she's thinking of is tenable. And then all that I'm saying is that it's untenable, but we're not saying that she needs to change it. So then she writes in her thing that is the same, what is it, 646 judgment. And she says that upon returning to my chambers, the respondent sent me an email requesting further time. I explicitly clarified that I was not requesting her for more time to file and serve submissions and subject to hearing from the applicants. I'm prepared to accede to that request. Obviously, she has to take their permission. She doesn't fucking get the benefit of the corruption that she's engaging in. She doesn't. By their email, the correspondents also seek directions about filing an application that I recuse myself. Not what I've said, but anyway, if the respondents wish to make the application, again, I've addressed this in the first discussion that we had, so I'm not going to do that again. But the point is that she says that we did not object to the listing of the dates that they had proposed. We never fucking got to it. She ran away before the other things we were raising as preliminary matters could be discussed. So now we go back to the thing, that the communication. One second. So that communication is sorted. Then basically she's asked for availability and stuff in the other proceeding as well, and she's made orders about the about why the interlocutory matters that we're seeking to be decided, including, and this is the reason why she does not mention the specific items or the specific orders. Let me actually bring up the interlocutory application, just so we are clear what was being sought. So this is a new interlocutory application that has now been accepted by the court, and I'll get to that in a moment. But the original one is next to it. It's next to it. So this is the application that was filed or lodged with the court that morning, and you'll see that it's dated 17 June, which is the same date as the hearing. This was the interlocutory application. This is what she's marked as MFI 1. So the first thing, contempt orders, which, by the way, we had sought even before Justice Bennett, and she had, except for the second one. The second one is about them trying to prevent us from reducing evidence in this proceeding by starting another proceeding for an improper purpose. Now, to clarify, we wanted directions orders about the conduct of this matter, because obviously we still have to file a statement of charge, we have to file affidavits, and seek discovery in relation to the
process to follow.
Exactly. It can't be, the way she ultimately did it, which I'll get to now. It's a whole fucking criminal trial virtually of itself. I mean, even though it's being done in a civil proceeding, but basically, if they don't get procedural fairness, they're not going to be convicted of a criminal charge in a criminal matter. And so, besides the concept of fairness to them, the obvious implications of her not scheduling the application properly is that she's setting us up for a dismissal, because ultimately then what she'll say is that I can't find them in contempt and convict them of a criminal offense, the board, even if it is a corporate entity, without us meeting the evidentiary burden that we have to meet, and without us being able to without us prosecuting the case properly. It's another thing that she's actively impeding us, or not even impeding, she's preventing us from having any shot at prosecuting the case properly. So this was the first order we were seeking. The second order was against the lawyers. The third order was that she permit us to issue a subpoena. Now, the reason why we had done this, even though we were not required to, was to put the other side on notice. So basically, it would streamline the process, and they could, if they had any legitimate objection, think of it and come up with it in advance. We had referred to the practice note, and basically it clarified that there was no obligation to notify them, but if it's a particularly controversial matter, though it should not be, because they shouldn't have had private correspondence with the judge who's also making ostensibly corrupt orders. But anyway, the practice note says that we should put the other side on notice if it's going to be a particularly contested matter, as a means of transparency and so on. That's what we did. This was to notify them, and what we get in return is them lying to the judge about a matter that really doesn't matter anyway, because it was not an issue stopple, and the decision of a judicial registrar is not binding on her for how she should exercise her discretion otherwise. So this is what we were seeking, very fucking narrow. Between these dates, any communication that they've had with Gorton, and in relation to matters that are integral to these proceedings, to the issues that we raised in these proceedings. That was the only subpoena we were issuing. We're entitled to get this discovery. We're entitled to get this pursuant to a right to a fair and public trial, which relevantly includes the right to get disclosure. And also the Civil Procedure Act or Civil Dispute Resolution Act in the federal jurisdiction. The disclosure of relevant information cannot be obstructed. So we say that, and then we say the court separately determined, and this is why what she did was so fucking rotten. She never mentioned the constitutional notice because it had been sealed by the time the discussion took place. It had been sealed at 9:36.
Mm-hmm.
The hearing was scheduled at 9:30, started much later. And by the time we started discussing the matters, the constitutional notice had been sealed. She specifically kept that out of the reasons. But the problem is that the constitutional notice was integral to the interlocutory application itself, because we were seeking a separate determination of the matters or the issues that we had raised in the constitutional notice. So the reason why she has not specified any of the orders that were being sought, basically she says they ambushed the other side with an interlocutory application. Doesn't matter what the content of the interlocutory application was, or whether we were even obliged to give the other party a notice of what we were bringing, but it was inappropriate because they were not prepared, and obviously she doesn't get the corrupt benefit that she would get if they're displeased with her performance. So, but obviously that's the subtext. She doesn't actually say that in her judgment, to be fair. Then the last thing is really about compensation for the.
Yeah, I understand.
Anyway, so those are the orders that were being sought. Now, this is really important because here she says, and I told her, I said, we want these things. And she says, well, why don't you write submissions about why interlocutory applications should be decided before final judgment? I mean, and I mean, it was just so fucking stupid. You couldn't. But then in her reasons, she says that I note that the submissions referred to in the order are not as to why the relief sought in the interlocutory application should be granted. So fucking dishonest. She has to exclude the particular orders being sought to say this. Because even, the most gullible people would not be able to accept this if she had specified that one of the things being sought was a subpoena. So obviously we need the evidence from the subpoena to oppose the relief that they're seeking, because our point is that the orders were not lawfully obtained, and that Gorton was, I was going to say fucking with them, but that would have been more appropriate. So this could not be said if she had listed the relief that was being sought. So it's clear that there's a reason why she did not list the particular orders that were being sought. Now, very important. So she said this, even I almost feel guilty calling them fuckers now after what she has done. Because anyway, so this is the email from their solicitor at Course, LSBs, that they note that the other interlocutory application, which basically, so they brought an application after midday for why, if we adduce evidence in an open court hearing about the unregistered former sex worker, and I say that because it was a criminal offense when she was doing that, why, if details about her were released to the public through an open court hearing, it would ultimately stop them from being able to do their job at all, which will improperly benefit us in court proceedings against them.
Mm.
And therefore, basically, the only thing they can conclude as the rational underpinning why we're raising allegations of corrupt conduct against them in a court proceeding is that we ultimately want them to fail in the court proceedings through obtaining an improper advantage, and therefore it is an intended contempt of court, and therefore they sought to not only prevent us from disclosing the details about that person or the other person who was purportedly blackmailing her to get her to make orders against her own former clients or prospective clients whom she had sent multiple sex videos to entice them into engaging her services. By the way, she was working as a senior associate at a law firm at the time, and exclusively sleeping with
quite extraordinary. Quite extraordinary.
Exclusively sleeping with people within the legal district. I mean, the person who complained once joked that maybe Gorton was one of the clients, and I was very particular in checking him because, don't want to conflate the horrible thing that he's done with any of the less horrible things.
And she had an involvement in my matter.
Everybody's matter, Peter. She's like the person. I mean, I'm not going to go into more details, but there is no way she doesn't have an involvement in the, sort of things that they do against lawyers to target them because of how centrally she's placed. And I mean, it's also sort of, it's proof of the level of arrogance they have. Put her in such a fucking prominent public position, despite knowing what her past is. I know that they know about her past because the commissioner was sent correspondence by a person on behalf of the guy who sent us the thing, the evidence, and the commissioner was told that this is what has happened. There's obviously a conflict. What are you going to do to investigate it? And basically, they said, fuck all. And if you dare, they basically threatened to have them criminally prosecuted. They tried to raise this matter further. I mean, they tried to use a technicality to justify the threat, but it was clear to them that they would get into trouble. Then the person who complained to us spoke with a bunch of lawyers. All of them sought advice. All of them told him that he will get fucked over very quickly. So he should keep quiet. Now, that also prevented him from getting protection under the legislation that protects whistleblowers, and they knew that he had this, obviously. So they're doing everything they can to go after him and basically destroy him and, seize the evidence itself. But he can't do anything because, and I mean, that's people like Downs and Gorton are one of the reasons why no one has confidence in the courts. I mean, not no one, but a lot of people. There's a 30% public confidence in the judiciary in Victoria at the moment. And I know that there's a number of other reasons for that too, but this doesn't help because not only does this contribute to a specific demographic losing confidence, but it's also people that would have otherwise tried to promote, good judgments or highlight to the other affected people that it actually functions. So they're also losing ambassadors for the court. I mean, lawyers are basically talking about breaking the law to get justice because they know that the courts is not where they can get it. And, we have extensive records of those communications about the complaints that we received from these lawyers. And anyway, so what their solicitor is saying is that they waived their objection to they're basically giving her permission to hear our interlocutory application. And also, during the hearing, I repeatedly told her that she has a duty to notify the Attorney General. And basically, I think she didn't really understand what I was saying because, I couldn't offer her any benefit. But he says it once, and she's on the case. Immediately, she issues directions to us to, serve the various attorneys general and so on and so forth. But anyway, so he says that you can list their interlocutory application, but he basically makes sure that, by the way, the only reason he does is because she's proved her loyalty to them during the hearing. She doesn't even let me fucking say the complaint. Forget about, ignoring it after it was made. She doesn't even let me make the complaint against their lawyer, deliberately lying to the court. So, they're perfectly confident that she's the guy. So, they want to seize the moment while she's still there. So then when she quickly dismisses the application to the next judge, they can say, this matter heard and decided. Anyway, so they say the contempt application can be listed and only half a day. So no directions about the contempt application. The first time it will be listed is for a half a day, and that's it. Final determination. So we haven't
process.
No. I mean, this is basically. No one can seriously argue that everybody who's accused of a crime, and let's say contempt, because the Criminal Procedure Act, let's say, applies to other crimes, and I mean, not to government bodies anyway, but everybody who's accused of contempt, if they could fucking draft the procedure that the court has to adopt for their prosecution, wouldn't it be good for everybody? I mean, at least then the court would gain a few more followers than it currently has, because at least the criminals would be more in favor of the court. Anyway, the point is that he says that it should be listed for, but also to his credit, he says we should be heard once before it's formalized, but Justice Downs goes above and beyond in service to the LSP. So she doesn't even hear us. Totally rejects what the directions that we had sought, and lists the matter for a single day, half a day hearing. So 1 day hearing in combination with another matter, very complicated matter. And so we don't get disclosure or discovery against him. We don't get to issue subpoena. We don't get to call witnesses. We haven't filed a statement of charge. We were seeking directions about, we can't even seek discovery before the end of 2 weeks from when we launched the affidavit in support of the charge sheet for their contempt. And then she'll basically dismiss the matter because the hearing is, we haven't complied with the formalities. Just give me 1 second. I'm gonna pause.